हो चुका है।
यहाँ पर जॉन जॉन्स पर्सनल मीटिंग लिखा आ रहा है।
यूट्यूब पे कोई नहीं, क्या कर सकते हैं। अ, जॉन जॉन लिखा आ रहा है यूट्यूब पे, उसको कुछ एडिट नहीं हो रहा क्या?
मैंने तो ये एडिट कर रखा था ना।
हाँ हाँ, तुमने एडिट कर रखा था।
हाय, हम
कैसी
लाइव
है?
हैं। ठीक है, हम
कैसी
लाइव
है?
हैं। बढ़िया है, 10 10 लोग देख रहे हैं।
इंशा, एम आई ऑडिबल?
यस यू आर। दीपक,
यस।
सी डू वन थिंग, एक मेरे को बात बता। मैं सीधी लिख रही हूँ ना कि
हाय,
अनिमा, द मीट
हम
इज
लाइव
लाइव।
हैं। ठीक है,
मीट लाइव है।
हम
कैसी
लाइव
है?
हैं। बढ़िया
प्लीज,
है, दस
वी आर
दस लोग देख रहे हैं।
ओके। अभी मीनाक्षी जी ज्वाइन करेंगी।
मेरे को
मेरी
बस
वॉइस
बता
एको हो
दो।
रही है। सी, अभी मीनाक्षी जी ज्वाइन करेंगी।
हम्म।
और मीट ऑलरेडी लाइव स्ट्रीम हो चुकी है। मैनी ऑफ इंटर्न्स हैव ज्वाइन। और मीनाक्षी जो भी ज्वाइन करेंगे उसके बाद हम मीट शुरू कर देंगे सेशन अपना, और यू कैरी ऑन द थिंग्स। बट
वन थिंग ना, मैं
इट
सीधी
इज
लिख
स्टिल
रही हूँ
लाइव।
ना।
हम्म।
और डू आई हैव टू मिरर वाला वो?
ऑल ओके।
ऐसा सीधा उल्टा ऐसा everything's fine.
Everything is fine, Anima. Meeting is live on YouTube, so
Shit, I'm sorry. I'm very sorry.
no issues, please.
We'll start when Meenakshi ji will join, na?
Yes.
Another team
She
leads.
is joining. She is joining. I'm letting her in.
Should I start right now or what?
No, just leave a message in the team lead group that asks them to join also, and then in the next 2-3 minutes we will join. Meanwhile, Insha, am I audible?
Yes.
Kindly keep on checking the YouTube channel and address all the queries that will be being asked by our interns. Don't leave any query
Hmm.
unanswered. Okay, just have a look on that also.
I'm making you the host, okay?
Good evening, everybody.
Hi.
Hi, कैसे हो आप लोग?
बढ़िया.
All good, Simran. I think we are live on YouTube channel, and
Okay.
Simran, just leave a text from your side in the common group of interns that we are live, and in another 2-3 minutes we are going to conduct this start this session.
Wait, I feel my net is not. Wait. Just a second. Deepak. इशू आ रहा है यहाँ पे बहुत बारिश की वजह से.
कोई नहीं.
हाँ जी, आप बोलिए.
आप एक बार जो हमारा कॉमन ग्रुप था इंटर्न्स का, आप उसमें एक मैसेज ड्रॉप कर दीजिए दैट द सेशन इज लाइव, काइंडली ज्वाइन ऑन यूट्यूब.
For sure, I'll do so.
ओके. अनिमा, एग्जैक्ट एट 7:05, मतलब एग्जैक्ट एट 6:35 डू स्टार्ट इट.
Okay. Done, Sim.
Isha, am I audible?
Good.
Yes. Hmm.
I think all our team leads have joined, and Meenakshi ji is also with us. Hello, Meenakshi ji. Good evening.
Hello, Deepak. Good evening to all.
Hi, Meenakshi ji.
Hi, Arunima.
How's you?
I'm fine.
दीपक,
Yes.
ये थोड़ा सा ऐसे पीछे को चल रहा है, मतलब कि मतलब ऐसे 5 सेकंड या 10 सेकंड पीछे. मीन्स whatever you are saying.
Okay.
There's no
uh,
issue then.
That's probably because the network connection issue.
Huh.
Otherwise, it is live now.
hmm,
The
Okay.
thing is, we
Join.
are live then.
Okay.
And I'll start by 6:35, no?
Ah, what am I doing? Hey, oh
What happened, Simran?
shit. Oh, wait.
Deepak, should I start by now?
Yes, you may start.
Okay. Good evening, everyone. A very warm welcome to all of you joining us live for the second session of our Pro Bono Legal Drafting Internship program organized by the Nyayavani Foundation. I am Arnima, Vice Chairman of Nyayavani Foundation, and I have the privilege of hosting today's session. It is wonderful to see our interns, guests, and viewers once again continuing this journey of legal learning together. As you all know, our first session faced some unavoidable technical glitches, which prevented us from carrying it out the way we had planned. But setbacks, as we believe, are never failures. They are stepping stones. They remind us to bounce back stronger with more determination and more clarity. And today, that is exactly the spirit with which we begin this second session. So, for those of you who are new, let me introduce briefly to our foundation. The Nyayavani Foundation is a registered Section 8 Pan-India recognized by Government of India. It is a people-driven initiative committed to bridging the gap between the law and society. We do this through legal awareness campaigns, pro bono services, and hand-on learning opportunities like this internship. Our vision is not just to polish drafting skills, but also to instill in young legal minds a sense of responsibility, empathy, and service to society, qualities that truly define the essence of profession. At the heart of this vision is our director, Mr. Deepak Sharma, whose leadership has been the driving force behind every initiative we undertake. His commitment to justice and social service has shaped Nyayavani into a platform where knowledge meets responsibility and where students can grow into just professionals, not just professionals, but change makers. Now, dear interns, I want to remind you this internship is not only about preparing drafts, notices, or petition. It is about learning to think with clarity, write with precision, and practice with discipline. Drafting is the very backbone of legal work, and skill you acquire here will stay with you far beyond this program. Yes, you will face challenges as we did in the first session, but it is in overcoming them that your true professional character is built. As I often say, great advocates are not made in courtrooms alone. They are shaped in their preparation, their drafting, and their persistence. Before we move on to the highlight of today's session, here's a quick reminder. Please make sure to update your LinkedIn's profile with the draft you prepared during this internship. Don't forget to mention Nyayavani Foundation and tag Director Deepak Sharma or Vice Chairman Arnima, Legal Advisor Pratha Parmar, Meenakshi Singh and Anjali, Internship Coordinator Simranpreet Kaur, and of course your respective team heads. If you wish, this will not only showcase your work but also strengthens your personal branding and professional presence. And now it is my honor to introduce our legal advisor and today's distinguished speaker. Ms. Meenakshi Singh is a practicing advocate in the Supreme Court of India as well as in various Delhi district courts. Beyond her professional excellence, she is a minimalist who actively promotes sustainable practice and lives by them. She is also deeply passionate about empowering and uplifting women, creating impact wherever and whenever she goes. Her journey reflects a rare blend of professional brilliance and social responsibilities, making her not just a legal expert, but also an inspiring role model for all of us. We are truly privileged. Excuse me, I'm
Hello.
I think there is a network issue from Anima's side. Meenakshi ji, we welcome you on board on this session, and we are truly grateful that you got your time and uh, for this session. And please, you may start with the session, and we'll do the introduction part and all the leftover part after this. So please start with the briefing.
Okay, Deepak. Thank you. Thank you to all. Hello, this is Meenakshi Singh, an advocate practicing in Supreme Court of India and all the entire district, Delhi district courts. And as he said, I am a sustainable life promoter, and I believe that too. And I believe strongly in women empowerment and child development. And I do that however it is possible. Um, Today's topic that we are going to discuss is notice, legal notice. So why we are discussing notice? Because notice is an initial point of litigation. You can't go to court without giving the notice. Like the life is very different from real life. We say, court mein dekh lenge tumhe. See you in the court. But it didn't work like that. In real life, before going to the court, you have to follow certain procedures, in which notice is the most important one. Without notice, you cannot sue anybody. Uh, I'm just sharing the PDF notice about notice, in which I have given certain brief points, from which we will not just know how to draft notice, but we will also know what are the essentials of notice. What what to keep in mind what draft. Just a minute, please. I hope this is visible to all.
Yes, Meenakshi ji, it is visible.
Okay, I'm just gonna discuss the briefs and highlights of it. Meanwhile, that Deepak, I would request kindly see the messages, as I'm not able to see. If there is any relevant query, please place it before me. Of the
Yes, Meenakshi ji, we got it. Ensure, please do the needful.
a request. Yes,
In-
by
Okay.
discussing notice.
Yes, yes, I am.
Notice.
Ma'am,
Visit him and say that I'm saying you that I'm gonna sue. Okay, cool. Hello,
Meenakshi, you are not audible. Yes,
I'm
please.
not audible.
I guess it's a network issue. You are not properly audible. Yeah, some people are here saying, no, you're not audible.
Hello,
Yeah, now you are audible.
hello. Am I audible now?
Yes, you are.
Hello. Hello. Should I continue? Am I audible now?
Yes, you are audible now, ma'am. You are audible now.
Hello.
Ma'am, you are audible now.
Okay, cool. I've joined with another idea as well. If here is some problem, I'll connect with that. Just a minute.
What's a
What's a
legal
legal
notice?
notice?
You
You
cannot
cannot
go
go
and
and
say
say
somebody
somebody
that
that
I'm
I'm
suing
suing
you
you
and
and
kindly
kindly
come
come
to
to
the
the
court
court
and
and
present
present
your
your
case.
case. what you will have to do, you will have to send him or her a written communication. It means that the notice should be in writing. And what should it consist of? It should consist of one's intention. And what's that intention mean? That intention is to clarify that you are gonna sue somebody for whatever damages he or she has done to you. Now, let's come and see who can send a legal notice. So anybody who is capable of, by law, that is all of you know, sound mind, 18 plus and all, they can send a notice. But how? They can send it in their individual capacity. Means you can send notice, but it should be properly drafted. It should show the law, what you're gonna plead in the court. So for that, it is very beneficial and very suggestible to go by a advocate or a lawyer who is knowing the law at least. Now let's see what the notice depicts. It means what's there in the notice. The sender's version of the events that resulted into the incident. Basically, we call it COA, cause of action. So what's the reason? Why are you gonna sue somebody? The main thing is that we have to show that why you're gonna sue somebody. This is what gives result to settle the matter out of the court amicably. Means if one is gonna settle the matter, if you have did something, you have no intention to hurt somebody, but still you have done certain sort of injury to someone, then you and the one who has got the notice, the recipient, you two can settle it out of the court. That's why it's very important to describe what has caused you the damage and how it has caused the damage. Okay. Then details and description of the incident itself. There you have to give the details and description of the incident, where it had happened, at what time it had happened. These are formalities that we have to go through, because in a person's life, many incidents happen of similar or same pattern. So for that, you have to, these things happen. There you have to clarify all this in the notice. Then the law, the sender relies on, yeah, this is a very important thing. You have to say him by you have to say him under which law you are gonna sue him or plead against him. Like when you will see the draft that I'm gonna share with you, there something is mentioned, tort law. So the draft we have today with us is about tort law. Then you will connect. You have to plead the law and you have to plead the section as well if you can. But section is not necessary. But at least you have to plead the law that if you did something wrong, then I'm gonna sue you for this. The time given to the recipient, again, the average time that is given in general common parlance is 30 days. The time given to the recipient to respond to the legal notice and a specific manner, if any. Not just the time. If you want to settle the matter in 15 days, in 20 days, you can give that. But a general time that is given in general cases is 30 days. After that, you have to also specify the manner how you wanted the notice to be replied, whether through WhatsApp. Suppose you are living in a village, WhatsApp is not working there, then you can specify that kindly send the reply to me by the post. And yeah, last one, the clear warning of intention of the sender to bring lawful action against the recipient. Yeah, there you have to mention that if you are not gonna reply my notice within such and such time, I'm gonna sue you. I'm gonna see you in the court. So this is to be mentioned there. Okay. I think till here everything is clear and I'm not going too fast. Let's discuss types of notices. There are various types of notices that you people can know, demand notice, but the main category on which we classify notice, there are two types of notices: pre-litigation and post-litigation. So the notice we are talking about is pre-litigation notice, that is sent by the aggrieved person through an advocate or in his individual capacity, but better to send it through an advocate because he writes the notice on his letterhead. And what's the result? If the recipient is not replying to the notice, then it will result into further legal suit. The purpose is very clear. This is just an opportunity to settle it out of the court. And yeah, notice is very important because sometimes it serves as an evidence. Now let's come to the court notices. It is sent directly by the court to the parties to the suit. And when if the recipient, any of the party can be the recipient here, the one who is suing or the one who is being sued. So in this case, if one is dodging the notice, then he or she is gonna get severe legal punishment, and it could result into penalty or even ex parte proceedings. You all are, I think, law students and are acquainted with the ex parte proceedings. Okay, how the notice could be sent? Mode. It could be sent through post, email, WhatsApp, etc. Anyhow, any other form could also be there. Sometimes notice is printed in the newspaper as well. So that is not a disputable thing. Okay. Time limit. As we talked earlier, time limit is 30 days in average cases. But there are certain sections, being a law student, you needed to know in which the notice needed to be sent prior. Like the time to reply the notice is needed more. Please refer to section 80 of CPC, Civil Procedure Code, where a 2 months prior notice is given to the government officers when a suit is to be brought against them in their official capacity. Suppose you are gonna file a suit against a public official, somebody who stopped you on the way without your fault or anything like that. So in that case, when you are gonna sue that officer in his officer capacity, then you have to give a 2 months prior notice. And likewise, in section 138 NIA, all know, Negotiable Instrument Act case, there is a notice to be given 15 days prior. It means you have to give the recipient 15 days time to reply to that notice. Okay. Now the issue that needed to be discussed, structure of a legal notice. How you going to draft a notice? Being a law student or being an advocate or soon gonna be an advocate, the legal notice must have at the top name and address of the parties. After this, I'll share with you a PDF of legal notice. I'll show you that is on the head of an advocate. I'll show you how the name of the parties are juxtaposed. See, the legal notice must have at top the name and address of the parties, both the parties. The sender's name should also be there, and the recipient whom we are sending, his name, and it is juxtaposed. The practice is like that it is written in front of each other. But it could be in different way as well. Depends upon the space and all. And the body of the notice, what you are going to write in the notice, and the body of the notice should contain the intention of the sender, as I discussed earlier. What's your intention? Why you are going to sue him? If you're going to sue him, then tell him that I'm going to sue you for this. The claim, what damage has been caused to him, and what he wanted in lieu of that damage. And other purposes, if any, with a warning that if he has gone unheard by the recipient, then the result will be a legal action. And you have to mention there that if you are not gonna pay heed to me, I'm gonna bring a case against you. The very two important things that I have added: presumption of notice. When somebody is sending you a notice, it is presumed by the court. If you have posted the notice or sent the notice through the WhatsApp, you needed not to adduce the evidence, because generally it is presumed that the notice has been sent. The court will presume that notice has been sent. But if the opposite party, that the recipient, wanted to say that no sir, he has not sent the notice, that's why I have not came to the court. In that case, the recipient have to give evidence to rebut that the notice has not been sent. Like how? Like you can go to the post and you can get check everything. You can show the WhatsApp that, see sir, this is the record detail of last 3 months. There is no notice, no mention. So there, if you are gonna prove that you have not got the notice or the notice has not been sent on your address, then you have to give the evidence to rebut the fact. rebut the fact of the presumption of the notice. Got that? So it is said that it is generally presumed that notice has been sent. When you will read section 27 of General Clauses Act, not necessary. If you wanted to read, you can go. And section 114 of BSA and earlier same section 114 of Indian Evidence Act, there you can read about this presumption that notice is generally presumed. Illustration A or something, you can read about notice in Indian Evidence Act, section 114. Now, let's come and see notice as an evidence. Legal notice is admissible in court as evidence. You all have heard about different types of evidence. It is treated as a documentary piece of evidence under the, so what sort of documentary evidence? Notice is presumed to be a documentary evidence and it can be given, and what will it depict there? It will depict that I have tried to do out of court settlement, that I have informed him or her, the recipient, that he's gonna be sued for this, and so many things you can make there. You can make the claim also of such and such rupees I have faced the loss and everything of that sort. And can be produced before the court to supply claim, defense, or case history. Okay, now I'm done with all the information that I could give you on notice. Now I'm leaving a blank, a thing to ponder that is out of this discussion. Very connective because I have got such a sort of problem with one of my friends. So you all are, who all are listening me, you have to reply me. What will you do if you are placed in such a position? What to do if a plain paper inside an envelope has been sent on your address as a notice? What will you do? Means your address has been mentioned on the envelope, but inside it you have got a plain paper. Nothing has been written on it at all. What will you? Will you presume notice? Will the court presume notice? Kindly tell me this. After the session, I will check the messages. And again, now I'm sharing the draft of the notice. Kindly. Taking a minute, please. I hope this is visible to all. Okay, cool. Let's proceed. See this, what I said that generally a notice is drafted on the letterhead of an advocate. That's why I have drafted, I have brought this draft here. See here, the name of the advocate has been mentioned. Yeah.
Sorry to interrupt, Meenakshi. There are some of the volunteers and they are answering your previous queries. Chaya Tiwari has said that.
I'll just please pardon, just a bit. I'll take it after the session. I have earlier mentioned there that after sharing the draft and giving them the assignment, handing over the assignment to them, I'll take the reply of that
Queries
question,
after this
please,
session. Okay,
because I'm in
okay.
the flow and my flow will get disturbed.
Yes, Meenakshi, please.
I hope they are understanding, and it's
Yes,
just a
yes.
request. Please let me continue.
Yes,
Okay,
Meenakshi, please.
cool. See here. This notice is drafted on the letterhead of an advocate. So this is a proper evidence. Suppose you are giving why these things are done, just to avoid the circumstances where opposite can be presumed, that notice was not sent or a fake notice they have themselves created, or to avoid these things, generally we draft the notice on the letterhead of an advocate. See, the name of the advocate is mentioned and address is mentioned here. After that, this reference number is advocates, they provided. Date is mentioned. And yeah, see here, to whom you are sending the notice to, OYO. This is the name of the recipient. Here it's mentioned. And my client means who is sending the notice, it is mentioned. I hope this is visible to all. And then you have to write the subject. Legal notice, you can write, you may avoid this. After that, look, the notice has been drafted. So under the instruction of my client, I, blah, blah, I, XYZ advocate, the name is mentioned, do hereby state you the following legal notice. You are saying him that I am giving you this legal notice on behalf of my client. When you will write the notice yourself, there you needed not to write that on behalf of my, there you can directly write that I am giving this notice for this thing. Then again, the facts has been mentioned. I'm not gonna discuss it. I don't think that I'm needed to. Look, the facts that has been mentioned. Please note that the client is a judiciary aspirant and she has taking various judiciary exams. I think she has booked the room at some hotel and she has been provided booking is yours and have paid for the same. She has reached the hotel in the evening and blah blah. All that has been mentioned here. She was denied with the check-in. Means the room has been booked and she has been denied the check-in. And she has already paid for that. Then the recipient is liable for providing her the services because they has taken the money. Okay. What they said, oh, you had ended the tie-up 2 years ago. So if you are booking or taking services through some platform, then they needed to provide now how the consumer should get through it that you have ended or whatever you have ended a tide or whatever. Their problem is she needed the service we provided. Okay, that my client, or I think they avoided to help her. So that's mentioned. So this is what I mentioned you that the incident. So in the first para, number 1, you can see the incident has been clearly mentioned. And this is also the cause of action on which you are taking the action for the legal suit. If the recipient is not gonna reply, you're not gonna make her damages to her. Then again, see, through my client, though my client get the refund of the amount paid, clearly the ID also has mentioned that you're also the platform through when you will file the suit, it acts as an evidence. So you have to mention all these things. Then that you are intentionally dodging the liability towards my client, which is subject to legal actions. It has resulted into deficiency of services to my client. Again, here the notice has not been properly drafted. Since when you will proceed forward further, you will see that here what has been done, breach of services, deficiency of services to my client. Here it's clearly written that you are intentionally dodging the liability which is subject to legal action. It has resulted into deficiency of services to my client. They are taking the money and you have not provided the services. This is prima facie a case of intentional harassment. They have not mentioned here clearly that it is under tort or under what, but they are on which they are going to take the action is efficiency of services. What is that? Okay, the prima facie case of to clear the exam for which she has prepared well. And what's important thing here? Deficiency of services on the organ. And what has it resulted into? It has resulted into intentional harassment and loss of an opportunity. So how will you connect it? When you will see, actually, it's a notice in which we are filing for a topic under tort law, in which you have stamina. We'll discuss it. It means the injury is there, but actual physical damage is not there. So she has not suffered any physical harm, but she has suffered the injury. Injury of what? Injury of loss of opportunity and intentional harassment. This is sufficient enough to take legal action. So this is how you will mention the law clearly. that my said client approached your concern for proper response and explanation, but your reply was most unfortunate and you tried to bypass your liability. See, here it has been clearly mentioned that this damage you have done, this damage you have caused to her. They have bypassed their liability, and it was the most, again, I think some facts are mentioned. We can I can leave it to you people to read. Response in this regard is most irresponsible, reluctant, and careless in manner. For your gross negligence, my say client had to suffer from monetary loss and mental harassments and loss of an opportunity. For all this, you are gonna pay her. For all this, monetary loss, you are gonna make her. Mental harassments, you are gonna make her, and loss of opportunity. Why this is clearly written? Because in these terms only, the court will decide the amount of the compensation that is to be made to the client. Clear is that? I hope that there was no attempt from your side to provide client satisfaction to my said client whatsoever, and my said client had faced a lot of harassment from your end, that due to these incidents and undesirable conduct from your end, my said client is going through huge mental agony. Again, taught, when you are not able to sue anybody under any law, then the gap is to be bridged by law of tort. That's why I told you that here the injury is, but actual physical damage is not there. Okay, again, such harassments of my said client cease to scare to take any trip and blah blah blah. Restoration of her faith and guarantee of security is next to impossible as per her. So here, what that the loss that she has suffered is not just about losing any opportunity. So there, the amount of compensation will increase. And the last one, you can see that as per the instruction of my client, therefore, you are hereby requesting my said client the immediate process of an amount of compensation of rupees 50,000 to my said client for causing all the mental harassment and for the legal expenses of my said client within 30 days. Now see, here, what they needed from the recipient has been clearly mentioned. They need compensation of rupees 50,000. That could be more losses done, that could be further decided. But if suppose the recipient is ready to give up 50,000, then there is no need to go to for the suit, and the matter could be closed out of the court. Otherwise, my said client, this is the warning. Warning, I said now there you have to mention the clear warning that I'll sue you. Otherwise, my said client will have no other alternatives except approaching appropriate legal forum, court, tribunal for appropriate legal remedies available to him. So there, she will move to the court if you are not gonna reply the notice. And kindly see the manner. I said you have to reply in the specific manner. So kindly contact at the above address or by email address provided. So here you have to specify the manner how you needed the reply of the notice. Thanking you sincerely, and then again sign off drafting advocate. Yeah, one additional thing, I have just seen that some cases and clearly in older practices, here on the left side of the notice, it was written a copy is kept with the sender. But it's not necessary to mention right now because now this is out of practices. So here you can, here it is written on the side that thanking you sincerely. In front of it, it could be written a copy has been kept with the sender. This is just for the purpose of evidence, but now in the modern practices, it is not adopted. So this was the draft I have shared with you people, and the assignment task I have shared with the team. They will provide you with that. It is same, more or less, and you have to draft the notice onto to see what has been given as a reply of the question I have posted. I hope I was clear while discussing this notice thing. I'm not able to see the messages. Could somebody help me, please?
Yes, I'll help you, Meenakshi. Wait. Should I tell you start telling you the queries that have been asked?
Please.
Okay, so here goes the first query from Danish, I guess. What is the evidentiary value of notice? Is it absolutely admissible in the court of law?
Yeah, it is admissible if it is properly drafted and everything has been clearly mentioned. And I said that notice is generally presumed and it is admissible. If you have drafted a well drafted, you have sent a well drafted notice with all the clear facts and it has been sent and you have those evidences with you, then it is presumed. It is also admissible. You can see the case laws on this point of. I have not mentioned the case laws here. You can do that. It is admissible. Yeah.
Okay, next is
Next
the
query, please.
answer of your next is the answer of your question that you have asked about a blank paper as a notice. And so there's Isha that said that she has said that no, there should be an expression of what exactly is to be informed, and then no, we cannot treat a blank paper as a notice. Then someone also write that no intention of the sender can be confirmed through a blank sheet. And court will consider
Yeah.
it, I guess, as the burden of proof lies upon the recipient. These are some answers
Fine is that.
from.
Yeah, rule is that if somebody has sent you a blank paper on your address, you have to send him a reply, him or her a reply that I have got your the liability is placed on you there to reply. Nothing has been written into it. So that is gonna secure your position if the case is gonna be lead court. It's just that.
Meenakshi,
Anything else?
a lot of students over here said that please lend this PDF to in the group. Share this to the group.
Sure.
The PDF.
Sure. It would be.
Plus,
It would be.
someone has asked that, ma'am, if a person doesn't receive the notice due to the delivery man, I don't know if it is a complete question or what, but it is a question over here because he put a question mark. Maybe
Like we have read
he or
earlier in the
she,
law.
whoever they are.
Okay, cool is that. Like we have read, the purpose of law is to do justice. Of each and every law is to do justice. So, in case you are able to show that there are reasonable circumstances because of which the notice has not received due, because and it's not on your fault. If you are able to prove that, then the court will give you the time because you have to give the evidence. As I said, the new notice is presumed. So it will be presumed that the notice is sent. But if you have not received it, you have to prove it. That it has been stuck in the post or it has been not, postman has dodged his liability or anything. You have to prove that. Because you have to rebut the presumption that notice has been sent.
That's all, Meenakshi. That's all the queries and the
Okay.
questions and everything over here.
Okay, I think I was clear with everything that I said.
Good evening, Meenakshi ma'am.
And
Hello.
I hope I did justice.
Good evening, Meenakshi ma'am.
Good evening.
Ma'am, I had a query with regard to the question you asked that if a blank paper has been sent to your address, should the notice include the address of an advocate? Only then would it be considered as a legal notice, right? Only then a person has to reply.
Please. Please go slow a little
Okay,
bit.
okay, sorry, ma'am. I'm really sorry for that. Ma'am, my query was that a person only has to reply to a legal notice if that particular notice contains the address of an advocate, right?
It's not like that. When we have read the PDF, we have read there that the notice can be drafted through an advocate or in a person's individual capacity as well. Note look, the main purpose of notice is just to put the knowledge in the mind of the recipient that I'm going to sue you for these
No,
damages.
ma'am.
So you can draft.
The
Yeah,
query was asked with regard to the question that you put to the students that what if a blank paper has been sent to my address? When do I have the presumption that the particular blank paper is a legal notice or not?
blank paper is never a legal notice. That's why we discussed now the essentials of legal notice. Damage, claim, cause of action that needed to be stated there. So in case you are sending a blank paper, just to be extra sure and go one step ahead of the sender, you have to do what? Just write reply that I have got a blank paper. And I don't consider it to be a notice. That's why I'm not replying you. If you have any problem with me, kindly write it again. It's just that. I hope clear.
Yes, ma'am, it's clear. Thank you so much.
Meenakshi ji, uh,
Yes.
go ahead, Deepak, if you want to say something.
Okay, so Meenakshi ji, there's a question from my side also, if I may.
Okay.
So yes, I was reading some judgments of Supreme Court about the electronic media and electronic evidence that circulated through it. So there was a point, and there was a Ovida dicta of Supreme Court also that even if someone puts a legal notice and through WhatsApp or through email, then also it will be considered as a proper legal notice. Means if it has all
Yeah.
the essential. So is it true
Yeah,
that
Deepak.
through WhatsApp also and through email that will be considered as legal notice?
Yes, Deepak. When something has been through proper evidence, electronic evidence, if something has been sent to you, it would be considered a legal notice. Not just that, I'm trying to clarify it. If some sort of print media, electronic print media is doing something, paper is coming, and like that's very long thing, not to discuss in that depth. But if something like we are reading e-newspapers, and suppose some fraud, PMLA cases of such sort of things have been done, such sort of case has been made, there you can write a general notice. Sometimes notice is general. Like you can write it, the case was with whom that I'm not able to recall the name. Very famous case, the man who left India with all the frauds and scams. So there na in paper also, the notice can be presumed from there as well. So e-media is a very proper medium to send notice.
Okay, Meenakshi, thank you for answering.
Ma'am, one more doubt.
Happy. Go
Uh,
ahead.
yes, ma'am. Ma'am, as Deepak pointed out that through electronic media also one can send a legal notice. Some people generally who are using WhatsApp, they have their blue text off that the other person does not know that the message has been received or not. So, ma'am, what if I have sent a legal notice to a person, but then the other person's blue ticks are off? Would it still be considered as that the person has received or?
You tell me a thing like um, I placed a chocolate in your hand. You kept it closed. You didn't eat it. That's not my fault. I sent it now. I have sent through my. I have evidence that. Now you didn't receive. That lies upon you. Prove it. Go and prove it. Who is that?
Okay, ma'am. Yes, ma'am.
You have ticked off or you have did whatever you can. I have done my part and I am clear with all my legal liabilities. Next lies with you.
Okay, ma'am. Clear.
Okay, Meenakshi ji, there are a
Anything else?
lot of Yeah, there are some questions. Firstly, people are asking about the assignment. I guess they are not clear about it. Can you please repeat what is the
Should I share?
assignment?
Actually, I have not shared the assignment. Should I share that PDF? I thought I'll send it in the group itself. But
Okay.
wait a bit. I'm just sharing the assignment as well. Give me a minute, please.
Yeah, sure.
Please.
And there are
Okay.
a lot more
Cool.
questions over here.
Okay. I'll reply all. Let me just not just share the assignment. Let me just also discuss the facts of the assignment so they could find it easy.
Meenakshi ji, if you want,
Yeah.
then we can share the problem statement on screen from our side.
Yeah. Wait a bit, Deepak. I'm just trying it.
Okay.
I need a time. Is it visible? Hello?
No,
No.
Meenakshi ji, it is not yet visible.
Okay. Let me just add it and cool. I'm trying it. I
Folks,
have
till
shared that
the
with Simran. Simran, I have shared that with you. I'm not able to share it from here. Kindly do that for me, please.
Meenakshi ji, I will do the needful, and in the meantime, Insha, please address the questions to ma'am, and ma'am,
Yeah.
please answer.
Okay, cool.
Yes. May I?
Yeah. Please go ahead.
So the first question over here is there any minimum time to read the notice?
Actually, the time to read the notice is not important. Time to reply the notice is very important. Average is 30 days, but certain case I mentioned in that in those cases the time varies. Like in case of government employees, officers, and in case of negotiable negotiable instrument act. In both cases, the time differs. To reply the notice.
Okay. I guess yeah. The next question is there any time
Done on my
period for
part,
the
please.
send?
Further question?
Yeah. Is there a time period for the sender also under which he
Sorry.
has to send the notice? Means he or she is
Yes.
asking that is there any time period for the
Yeah.
sender also?
Very smart question. The time period is the period of limitation to file any suit. Like if you have 1 year to file any suit for defamation, or you all know period of limitation is what? The time limit that has been decided by the law to file any suit. So in cases where there is to file suit, it is 1 year, then you can give a notice within 1 year. So there is no such mentioned time for the notice, but yeah, here the period of limitation will work. Like if you have 3 years to file a suit against some breach or of contract or something, then there it may be 3 years. So, like it is what? It is just a part of legal remedy, na initiation, na. So get the you too have the time to send. After that you can't. Like the cause of action has been expired, yeah, then you can't send the notice. Next one, please.
Okay. Okay, the next question is, can a general text between two people who have some conflict be considered as a legal notice without an advocate?
No, how could it be? I said, now legal notice has certain requirements that needed to be met, now. How could it? No, general legal text could not be sent as notice. No, you have to draft a proper. Then what's the difference between a legal notice and a notice?
Oh,
Legal
Meenakshi
notice is
ji,
what? You have, yeah,
he further described the question over here. Like if
yeah,
someone
now
tried to
finally,
inform the other person regarding the damage or compromise without any proper legal notice through an advocate, will it amount to legal notice?
no, it would not amount to legal notice. It is certain sort of negotiation that you are doing out of court. Court will not presume it to be evidence, na? What does the notice? Notice का एक जो सबसे important function है, the most important function of notice is that it is presumed to be an evidence. It can be adduced as an evidence. So in that case, you can't give the evidence na in court that I have sent a legal notice. You can't produce an advocate as a witness na that he has said and he will do. You have to draft a proper legal notice to claim the damages as well.
Okay, the next question is, can we issue a legal notice publicly, like newspaper or via social media against individual or a
Yeah.
company? If yes,
Yeah.
can it in any circumstances amount to a defamation? Means if we are publicly giving a legal notice, can it amount to defamation?
Again, we are trying to bring too many laws under one compartment. So let me be clear with the fact that defamation also comes with certain provisos. I hope you all have read. If you are publishing something right, that is true, that's not defamation. So if I am bringing a legal notice against somebody that is true, how could it be defamation? So not going out of the context, but again, it can be in very high profile cases, it could be published publicly. And there should be there should be a certainty that is being read, that the recipient has the access to that platform or whatever e-media you are trying or whatever you are publishing. Like you cannot publish a legal notice in some place where the recipient didn't have access to. Done with the question, please.
Okay. The next question is, offer letter can be sent to the other party. Yeah, obviously, that's the
Offer
basic.
letter is what? Offer letter is something very different. Why should we discuss here? It's a class relevant with notice, na? We needed not to discuss offer letter here. Offer letter is something
Okay.
between employer and employee. That's very different thing. That didn't act as legal notice. Again,
Okay. And the next
yeah,
question
it
is,
can
if
be
a
used
legal
as evidence. It can be given as evidence in case of employment to prove that you have been employed and blah blah blah. But it cannot be termed as legal notice.
Uh, in short, we are not
yes.
taking the next question that is about the NI Act because our next assignment will be going to be about the NI Act. So all your
Okay.
queries will be answered there. Till now, we have focused on legal notice, and I think there's another. Insha, take a last question, and then we will move on to the internship drafting task.
Yeah, sure. Okay. Okay, the last question is, cause of action का पता बाद में चले तो क्या हम नोटिस भेज सकते हैं?
Cause of action ka pata, like if you got the cause of action, the knowledge of the cause of action that has occurred after the time of the period of limitation, then you can't do anything. That's your fault, na? There's a clause that you cannot sleep upon your law assumes you to not sleep upon your right. You have to be vigilant. Vigilantia, no, but some I'm not able to recall exactly, but there is a maxim that you have to be vigilant. So after it's your fault na, that you got to know the cause of action after period of limitation. If once the period of limitation is being crossed, you can't do anything. Neither you can sue nor you can send the notice.
Okay, Meenakshi ji, there's one last question, and it is
Okay,
important. It is a good question. Can a legal notice be revoked by the sender if the sender thinks that it is inadequate or there is a mistake in the notice?
Look, it cannot be revoked if the another party, the recipient, has got the notice, he have received it. Then how could you revoke it once you have sent it out of your hand? Again, you have read the rule of communication in contract. Not gonna do that here for you. In that case, if it is out of your hand and it has been sent to the recipient, then you cannot revoke it. Yeah, you can place another letter or notice that I am taking back. So I needed not to proceed it further. I'm not gonna sue you. So that notice should be not taken in mind. You can draft another legal notice or another evidence sort of thing for that. But legal notice once sent is sent. He received it. He will be prepared either to make your damage or to go to the court.
Okay. Done with the questions.
Cool. I should proceed with the internship task now.
Yeah.
Okay, thank you. See here, please. Internship drafting task. Again, this is under the umbrella of law of tort, and the topic is injuria sine damno, like injury without damage. Injury is there, some sort of legal injury is there in